Hi everyone, this is Manvi Singh and I am a law student of IME Law College and I am a legal intern in LEXIS and Company. So the topic is Section 11 and Section 14 Arbitration Act 1966. The judgment was passed by Delhi High Court, Delhi Court on the issue of appointment of arbitration to form an arbitral tribunal. Section 11 of the Act pertains to the procedure to appoint arbitrator. First one is by an application to the concerned High Court for appointing a sole arbitrator whereas the second procedure requires that two arbitrators appointed by the parties to the arbitration agreement shall appoint a third preceding arbitrator. So now the Section 14 of the Act deals with the resignations, termination of the appointment arbitration. The ground for the resignation are inability to perform the duty de jure and de facto. There is two maxims, or where he himself withdraws for the cases sitting any other reasons. The grounds for the termination can relate to the interdependence or impartiality of the arbitrator, where the parties terminate the mandate of the tribunal. So now this is the little bit explanation of this topic. It is the pretend to mention here the judgment of the Perkins statements. In this judgment, the Supreme Court has held that a party does not have a sole rights in appropriating and appointing an arbitrator. The parties individually or together must first approach the High Court for appointment of arbitrator. Therefore, where an arbitration clause gives right to only one parties to appoint an arbitrator, the parties cannot appoint the arbitrator itself and initiating the proceeding. Now, the Delhi High Court is the judgment Raksha Vigyan Karanchari Sharankari Awaz Simiti versus Proto Developers and Technology Private Limited held that where a party appoints a sole arbitrator without approaching the court, then the appointment shall be invalid and the second party has the right to approach the court under Section 14. The respondent in this case has solely appointed an arbitrator without court intervention. The petitioner then approached the Delhi High Court for appointment of the arbitrator, to which the respondent objected. However, the court in this case dismissed Section 11 petition with the liberty to the petitioner to approach the court under Section 14 of the Act. Now, thereby rejecting the appointment of the arbitration by the respondent and the replacing appointment with the arbitrators. This is perfect example of the conversion of Section 11 application into Section 14. So now, first approach of the High Court was appointed to the arbitrator. Therefore, it was a pretended to mention here the judgment of the Judge Prince Eastman. So the ground for the termination can relate to the independency or impartiality of the arbitrator, where the parties can terminate the mandate of the tribunal. The ground for the resignation are inability to perform the duty de jure or de facto, where he himself withdraws from the cause of sitting of any other reasons. The Supreme Court has held a party does not solely right in appointment and arbitration. The concerned High Court for appointing a sole arbitrator, whereas the second party procedure requires that two arbitrators appointed by the parties of the arbitration agreement appoint a third party presiding arbitrator. the judgment on the issue appointed of the arbitrator to form an arbiter tribunal. So guys, this was the section 11 and 12 Arbitration Act 1966. I hope this clear to you all. Thank you so much for listening me. Like, comment and share.